I'm Tessa Czislowski and I'm a family lawyer at Ward Keller. Consent orders allow separating parties to formalise their property or parenting agreement, or both. They are made administratively, so there's no need for parties to go to court. So there are some legal requirements for consent orders. For property matters, the agreement must be just and equitable in all the circumstances. That doesn't mean that the agreement has to be equal, it just has to be able to be justified to the court as to why you've reached that agreement. For property matters, you also have to bring your financial relationship to an end. For parenting matters, the agreement must be in the best interests of the children, and for both property and parenting, the agreement must be able to be enforced. It's important to get consent orders because it formalises the agreement you've reached with your partner. So for parenting or property, it makes the agreement very clear. There are some real benefits to doing property consent orders because it does give you a stamp duty exemption. So if you're transferring property between the two of you, you don't have to pay stamp duty on that, and that can save you quite a bit of money. You also get a CGT rollover, so a capital gains tax rollover, and without consent orders, you can't split your superannuation if that's part of your agreement. So there are some other ways you can formalise agreements, binding financial agreements, and for parenting matters, you can also use parenting plans, but they are not actually enforceable by the court. If you don't have consent orders or a binding financial agreement, the agreement that you've reached with your spouse isn't able to be enforced. The usual process to obtain consent orders is someone comes to see me. We can only see one of the parties of the relationship, but if you come in to see me and you've got an agreement, you say this is what the agreement is, I have to get some information from you, some background information, as well as the information about the actual agreement. For property matters, you must provide me details of all of your assets and liabilities and your superannuation. Even if that's not part of the agreement, I need that information and the court needs that information. Once I have that information, I can prepare the documents, send a copy to you as the client. You have a look at them. When you're happy with them, we send them to your ex-partner. They have a look at them. If they want to get some legal advice, they can take them to their solicitor. Then both parties sign them. We file them with the court. They get sent to Adelaide and we should have them back in 2 to 4 weeks. So consent orders can't deal with child support matters. So if you've come to an agreement with your ex-partner about how much child support they're going to pay, or about one party paying for things like school fees or medical procedures, that can't be part of the consent orders. We can do other types of agreements, child support agreements dealing with those issues, but we cannot put those specific issues into a set of consent orders. Ward Keller does consent orders on a regular basis. We do them really, really often. That's actually one of the biggest parts of our practice, of our family law practice. So we have flat fees for consent orders. Depending on the type of consent order that you're getting, we can give you a flat rate so you know exactly how much you're going to be paying from the outset, provided you and your ex-partner have reached an agreement. If you haven't reached an agreement, we can help you go through that process to negotiate an agreement and then formalise it into a set of consent orders.